Now, for the Hansard record, could you please state your full name and the capacity in which you appear today?
Rachel Louise Walmsley. I'm the Policy and Law Reform Director at EDO New South Wales, appearing on behalf of the Australian Network of EDOs.
And I'm Nariman Aspi Sahuka, Senior Policy and Law Reform Solicitor at EDO New South Wales, and also appearing on behalf of the Australian Network of EDOs.
Okay, now would you like to make a brief opening statement before we go to questions?
Yes. Thank you for inviting us to make a submission and to appear by teleconference at the hearing. Since writing our submission, just so you're aware, we're now known as EDOs of Australia. We're a network of community legal centres located across Australia. Each EDO specialises in public interest environmental law. So for the past 30 years, we've advised Australian communities on how to protect the environment using the law. This includes community advice lines, written advice on public interest matters, casework, legal education and law reform. Our law reform work mainly relates to two areas: improving environmental protection and improving community participation in decision making that affects the environment. We are not trade law specialists or international law experts. However, we do seek to identify relationships between environmental laws and other public policy areas. The terms of reference to this inquiry are an example of this. In summary, ANIDO believes there's a strong case for strengthening environmental assessment and review of treaties and other international agreements. We support a framework to ensure that treaty-making processes properly consider the public interest in environmental protection and its increasing linkage with economic and social factors, reflect Australia's commitments to ecologically sustainable development, or ESD principles, and require best practice transparency and community participation. To achieve these aims, our submission outlines ways to improve environmental review in Australia's treaty-making processes. In particular, it proposes 4 complementary measures. Firstly, treaties and related actions should be accompanied by environmental impact statements. Environmental impact assessment, for your background, is a well-established tool for estimating, avoiding and minimising the harmful environmental consequences of a policy, program or activity. The results of an EIA are set out in an environmental impact statement, or EIS. A formal EIS procedure would better inform decision makers, the Parliament and the public. It would also provide a point of reference for post-implementation reviews. To be effective, as we note in our submission, the EIS procedure would need to occur early enough in the process to influence negotiations, be iterative to evaluate immediate and longer-term implications, consider compatibility with Australia's domestic and international environmental obligations, include consultation between departments, governments and the public on impacts and alternatives, and should have a process to exclude treaty actions where they will clearly have no environmental effects. This could include a preliminary review that is made public early in the process. Our submission points to 2 existing frameworks that could be adapted to assess Australia's treaty making. And these are not off-the-shelf models, but they demonstrate that the expertise, capacity and feasibility is there. For example, Australia's National Environmental Law, the EPBC Act, triggers federal environmental assessment and approval in certain limited circumstances. However, the EPBC Act does not have a specific role in scrutinising treaty making. In the US, we understand that executive orders require environmental reviews of international agreements, such as trade agreements. These reviews include expert advisory groups, reports to Congress and public consultation. We can't comment on the rigour of individual US assessments or reports, but the processes outlined in the US framework provide one example that could be adapted to Australia's circumstances, and there are others. In Australia, we understand that the National Impact Analysis, or NIA, aims to consider the foreseeable social, economic and environmental consequences of treaty actions. However, references to environmental impact in NIAs appear very general and in some cases fairly cursory. We're not aware of specific assessment processes that underpin and inform those NIAs. I'll now turn more briefly to our other 3 recommendations. As a logical progression of the EIS procedure, Australia's treaty-making processes could adopt a statement of environmental compatibility. This is analogous to existing compatibility statements on human rights. Statements of environmental compatibility would refer to how the treaty will be compatible with key environmental treaty obligations and principles of ecologically sustainable development. Accordingly, our second recommendation is that a statement of environmental compatibility should accompany treaty-making proposals laid before Parliament. Thirdly, we say that a National Environment Commissioner should provide advice on relevant treaties. And it's worth noting some context around this proposal. To be clear, this is not a proposal that relates solely to international treaty making. In 2009, the 10-year independent review of the EPBC Act recommended a National Environment Commission be established. The Commission was to play a strategic, arm's-length role that encompassed advice, review and oversight of decisions affecting Australia's environment. In 2013, the Senate Environment and Communications Committee reiterated the call for this independent commission. Given the potential for international treaties and agreements to have flow-on effects for the environment, we believe a National Environment Commission would be well placed to advise the Parliament on potential impacts of treaty making. For example, the Commission could report directly to Parliament on treaty making processes that affect the environment, oversee national and international compliance and environmental performance, and conduct environmental performance audits and review outcomes. Finally, ANIDO agrees with the general principle of open government that a proactive culture of engagement, additional scrutiny, and better public access to information will enhance the processes of government and improve the outcomes sought. Australia's treaty-making processes, including the 15-day sitting day tabling period, could be made clearer and more certain if they were set out in legislation, as has recently occurred in the UK. Accordingly, our fourth and final recommendation is to improve the openness, accountability and consultation opportunities in treaty-making, reservation and reviews. This could occur by fostering a proactive government culture of engagement earlier in the process, including on detailed treaty text, setting out scrutiny procedures in legislation, reviewing the adequacy of parliamentary review timeframes, and setting clear timeframes for government responses, and engaging transparently with public concerns about trade treaties, such as investor-state dispute settlement clauses. Thank you.
Thank you. Senator Whish-Wilson.
Thank you. I was just interested in your views. Yesterday we heard that the WTO, from some witnesses, had, I suppose, grinded to a halt, and that's why we've seen a proliferation of bilateral trade deals and multilateral trade deals like the TPP. Do you think the inclusion of tougher environmental standards, as an example, is a fair thing for trade deals?
Well, certainly the nexus between trade and the environment is a really critical issue, and the more agreements that we have and that are signed, whether it's at a multilateral level, a plurilateral sort of regional agreement or bilateral agreements, the cumulative effect of those agreements prioritising and enforcing trade related outcomes means that it's really important that those trade agreements also consider what are the potential environmental impacts of those agreements, and that when it comes to potential conflicts between environmental outcomes, including previous environmental obligations that Australia or other countries might have signed up to, conflicts between those and new trade deals, that there is a clear process for working out those relationships and to try and make them pull in the same direction, rather than the trade-related clauses being binding and enforceable and effective, and the environmental treaties or the environmental obligations and impacts either being ignored or being left behind and not really prioritised in the context of those trade agreements.
Or perhaps could be used as greenwash as a way to sell the deal. Yesterday, the Financial Review editorial talked about the need for an emissions trading scheme, but was talking about the need to get our regional partners involved in such a scheme, and of course other countries around the world, for it to be effective in emissions reductions. I mean, do you see something like the TPP with 12 countries as a good forum for getting negotiations on a binding agreement with our neighbours. Can trade be an opportunity, or is this potentially a missed opportunity?
I don't know that we'd have a particular view on the use of the TPP as that sort of forum, because we're not, I guess, trade specialists, and we're not across the details of the TPP and how that would, bring in things like an ETS. I mean, I do think that there needs to be, I guess, strong regional cooperation on environmental issues, and that Australia can play a capacity building role in relation to domestic environmental regulation to assist our neighbours, drawing on our own expertise, and also to take some sort of leadership role in pressing an agenda of environmental protection that ultimately is not just about protecting the environment, it is about protecting our society, our way of life, and about protecting our economy into the future. But I can't express an opinion on whether the TPP is an appropriate forum for that. Certainly.
Could you say whether you? I mean, I've heard that there was discussions, and we have had a leaked text that talks about things such as deforestation and sustainable fisheries in the region. Is it when you mention environmental standards, is there any particular area that you think these deals should be focused on?
Well, I guess it sort of depends on what the agreement is setting out to cover, and that's really the role one role of having an environmental impact assessment process, is that you can cover off or look at what are the various aims and means of achieving those aims in the trade agreement, and what are the linkages that create potential impacts on the environment as a result of those changes. So there's a lot of effort obviously invested into what are the trade advantages of entering or disadvantages of entering into a trade agreement. But there's not as much focus and not as much resources put into what are the potentially unforeseen consequences, what are the foreseeable consequences that we already know about, and what's the procedure for working out how we can avoid and mitigate those changes. I mean, I understand that illegal logging, or at least unsustainable logging, can be an issue, and you've mentioned fisheries there as well. There are a range of potential negative impacts that could occur from any specific agreement, and what we're saying is there needs to be a framework to assess what those impacts are. And bearing in mind, there could be positive impacts in the sense of making green technology cheaper or something along those lines, but you need to weigh up both the benefits and the risks and the costs from an environmental perspective, and you need to do that in a way that's in reproducible form, but that can be customised to whatever is the particular agreement you're looking at, whatever its clauses say, whether it's the TPP or another type of agreement.
Could I just get
into whether the TPP is an appropriate agreement or forum for an ETS? I think we'd have to say, while the environmental chapter is included but is not actually enforceable, while environmental standards aren't enforceable, then it's perhaps not the best mechanism to actually guarantee environmental outcomes. Might be trumped by other trade clauses.
Yeah, it's interesting because I think we heard from an expert witness yesterday that was the expectation at the beginning of the TPP, which has been 5 or 6 years now, whereas we've seen leaked chapters that have shown that clearly these things aren't enforceable. Our government has stated on record that they don't believe trade deals themselves are appropriate forums for getting environmental outcomes. Can you just clarify why you believe there should be environmental impact statements? Is it because these business activities have created externalities and environmental impacts? Why do the two go together?
Well, I mean, it can be argued that trade agreements are not necessarily the best vehicle for environmental outcomes because they're for a different purpose. But our concern is that they have a potential for very significant environmental impacts. And so that is something that is a matter of public interest and that should be fully examined and scrutinised before the treaty making or agreement making processes are finalised. I think in our submission and the submissions of other witnesses, a lot of the issues come around there may be some form of consultation, but that's either not on the full text or dependent on reading leaked versions, as you say, or actually the consultation meeting might be a tokenistic meeting that happens after certain clauses are already settled or already negotiated. So our recommendations are about just improving the transparency and accountability of these kind of processes, because the environmental impacts are a public interest, matter of national interest, even though trade agreements aren't necessarily explicitly about the environment.
Could I just ask, do you think, once again, we've heard a weight of evidence that they're no longer about what people associate as being traditional trade. A new generation trade deal like the TPP is about, deregulation and changing laws and regulations across countries on issues such as IP, local procurement. There's a whole range of things. Do you think that with these new deals, it is substantially more important to incorporate them into trade deals? So incorporate environmental impacts into trade deals?
Well, certainly to look at the flow-on consequences of, of the various provisions and the various issues that are canvassed in these broader agreements. As you say, they are expanding beyond traditional, WTO measures to WTO plus so-called measures, there can be a range of externalities and a range of impacts that flow on from those, and those deserve specific scrutiny, and we don't feel like that's being elucidated, or that those impacts are being considered in the detail that they should be. And in terms of incorporating environmental standards into those agreements, I haven't seen the text of the TPP chapter, for example, and I guess we are starting from a position of significant information asymmetry here, where we can't see what can't reliably see what the provisions are at any given time, because there is that lack of transparency. As lawyers, we like to see the detail, we like to see what the wording suggests, and if we look back at, say, the Australian-Korea, or the CAFTA, Korea-Australia Free Trade Agreement, the provisions in the environmental chapter are very general. They talk about endeavouring to do various things, but they don't really say how that environmental cooperation or those environmental standards will be carried forward. And they don't have any time frames or anything around how those things will be achieved. And if ultimately a party doesn't comply with the environmental chapter, well, there's nothing in the agreement to enable the enforcement of that chapter anyway, unlike other provisions in the agreement. So, for example, if you came up with a potential conflict under that agreement or under another agreement in similar circumstances, conflict between the trade-related aspects of the agreement and the environmental standards, well, there would certainly be more incentive to comply with the trade standards because they're binding and potentially enforceable, and the other party or another party could, take you to a dispute resolution settlement on that issue, whereas if there's no way to do that for the environmental chapter, then it sort of begs the question, what is the role and effectiveness of having that chapter there? I mean, I think it is good that it's there, but it does need to be on an even keel with the trade-related aspects of the
Okay. We've also heard evidence that individual chapters are important, but it's also how the chapters relate to each other that is critical, particularly the investment chapter. And of course that is likely to include investor-state dispute settlement clauses. Is the EDO aware at all that there's been any carve-outs for the environment? We've had Minister Robbs talked about carve-outs to health under ISDS, but are you aware that there's been any carve-outs for environmental safeguards and litigation from large corporations on environmental matters?
Look, we can only say what we've read in the media, and we haven't been privy to, we haven't engaged the level of detail where we've been privy to the details of whether the environment will be excluded or not. And I guess, we are relying on potential, leaks and so on of chapters in order to comment on these issues, and that's not a level that we've as I say, we've engaged in, but whether the environmental protections from something like ISDS, so let's say that there has been statements that the environment or environmental policy would be excluded from ISDS. Well, the wording on the chapter hasn't been settled, and we don't know, what that's conditional on, and we don't know, what the definitions are around, what environmental protections are excluded. So, for example, what is an exempt environmental law if there was an exemption for those under the ISDS clause? Does that include planning laws at a state level? Does it include mining laws that may include environmental protections in them, but they are set up to facilitate the extraction of our resources? Or is the reference to environmental laws much narrower than that? Is it just talking about our biodiversity conservation laws, for example? And I guess in terms of exclusions, it's unclear whether those exclusions would just apply to Australian environmental laws. So if Australia is putting up its hand and saying we don't want ISDS at all, or we don't want ISDS in relation to health or environmental policy, what does that mean for a developing country that's trying to strengthen its environmental laws? So could Australian or US corporations sue a developing country for doing that? Now, to us, that's not an equitable situation that we should be demanding of our developing country neighbours, and it could also unpick other important work that the Department of Foreign Affairs and Trade and many others are doing in this area, including ourselves, to enhance environmental laws in the countries of our Pacific neighbours and to build their capacity to protect their own environments.
Thank you.
Any other questions? If not, we thank you very much for your submission and your appearance by telephone conference here today. And we now move to representatives from Choice.